I am a managing attorney at Montana Elder Law. I focus and specialize in writing estate plans for Montanans, and I help folks plan for long-term care needs. Generally speaking, I think that's going to mean I help people figure out how we're going to pay for nursing homes, or how we're going to keep people in the home if we need care in the house, or what assisted living facilities are going to be the right fit. Can run the gamut. So I'm going to talk today generally about elder law. And when we do that, first, my disclaimer, not going to be giving any legal advice today. Everyone listening, you are not my clients. We don't have an attorney-client relationship. I don't know if we're going to be doing questions. People can interrupt me, but generally speaking, don't give me specific information if we're going to ask questions. All right, so elder law, that's what I was asked to present on, and I realized as I was working on the presentation that this is actually an incredibly broad concept. Generally speaking, I think elder law is going to mean any one of these things, including writing estate plans, planning for incapacity, maybe guardian conservatorship process, long-term care planning, so planning for nursing homes, bringing claims about abuse or exploitation of individuals who are elders. And it might even be anything else. If you've got a client who's an elder individual, it might be landlord-tenant law, maybe it's contracts or anything else. In order for the talk to be somewhat useful, though, I decided that I was going to focus mostly on long-term care planning. And what that means in my mind is we're going to talk about Medicaid. If I can finish the Medicaid stuff quick enough, I will then talk about estate planning. But I get the feeling when I'm talking with folks that there's a lot of information that's not necessarily correct, or everyone has heard something that's slightly wrong. And so what I want to do today is talk about Medicaid rules and what those rules are so that we can all see how they come into play. Here is a funny / dark little joke for us elder law attorneys. Basically, the idea here is if you don't think through who's going to do what and what you want to have happen, then you don't particularly have a good plan. So with that in mind, I'm going to scroll down to my Medicaid planning. And we're going to talk about long-term care. All right, so we're talking about long-term care because long-term care is incredibly expensive. There's lots of folks who are going to be needing care in the next 30 years. Baby boomers are working their way through the system. There's 78 million individuals who are between 53 and 71. And generally, most folks are going to need some kind of care. Now, that doesn't mean someone's going to need nursing home care. That might just mean they're going to need some care in the home, but it could include nursing home. Average care that someone's going to need is about 3 years. And one of the numbers that kind of scares me personally is that if you're 65 or older, you have a 1 in 8 chance of being diagnosed with Alzheimer's. Tack on to that we're getting really good at keeping people alive. You will see that the average age has increased drastically from 1965 to 2017. And just recently, the last couple of years, we've been seeing significant issues with regards to COVID. So nursing homes and in-home care facilities and companies have been having difficulties staffing. So it's been hard for them to get folks to work. Wages have increased and the facilities have limited space. It's, we're constantly going to be hearing about facilities closing the door. So that's, we have a long-term care crisis, coming and working its way through the system from a demographic standpoint. You tack onto that how much it costs to go to a facility to get care, and you can start to realize that this is a significant issue that has a lot of liability for individuals. We're talking $40,000 a year for assisted living facilities, upwards of $100,000 a year for a nursing home. And it's worth noting that the costs are all post-tax, meaning if you're using your IRA to pay these costs, those are funds that you're going to have to pay taxes on. These numbers are coming from Genworth's annual cost of care survey, and they do that on an annual basis. So these are relatively accurate numbers. And, we see that costs are increasing about 4% per year. So they're not coming down. We're not getting better at providing the care. Now, when we talk about how we're going to pay for care, one of the common things I hear all the time is, well, we have Medicare that'll cover it. And that is not true. Medicare will pay for a little bit of nursing home care, but only if that care is coming after you've been discharged from a hospital. So what that means is you have to have gone to a hospital, been admitted for 3 days, and then the hospital discharges you to the nursing home for skilled nursing care. And that is generally done for rehab. And if you meet those requirements, then Medicare will pay the first 20 days of your care 100%. And the next 80 days, Medicare is going to pay 20%, which means you have to pay 80%. After 100 days, if you are still at the nursing home, that is no longer rehab. You now need that level of care. And so Medicare is not going to pay it all. So your next step then is you are going to pay privately. Generally speaking, what I'm concerned about as someone who helps folks plan for nursing homes, I want to know what's our cost of care, less what's our income. If we have a net loss every month, then we know we're going to have an issue because we're now needing to liquidate assets to pay the facility, right? So that means using your bank accounts, your checking accounts, savings accounts. It means, liquidating your IRAs, your 401ks, your investment accounts. If you have rental property or mineral rights, that means selling those assets so that you can pay the facility. Now, some folks might be lucky enough to have long-term care insurance. I don't run across that many people who do have policies, but there are folks out there, and it's nice when we find them. If you have long-term care insurance, the benefit is that insurance policy is going to help offset the cost of care. So it's going to bring your net loss every month to a smaller net loss. Generally speaking, those term long-term care insurance policies aren't written that often. The long-term care insurance companies did a poor job underwriting them. They didn't estimate that so many people were going to keep their policy, and so everyone who had one kept it, and so they all used it. So it's challenging to qualify for them now if you want to go and buy them. If you ran out of your personal assets, you don't have any long-term care, then ultimately, if you run out of money still, then you still need to go and you still need nursing home care or assisted living care, then there are public benefits that will help pay for your care. We're talking specifically about what's called the VA pension program and Medicaid. I'm not going to talk about the VA pension today, mostly because I don't have slides for it. And Medicaid is going to suck up enough time already. So we're going to talk about Medicaid. Medicaid is the payer of last resort in the long-term care perspective. So common Medicaid myths that I see. So like I said, the first common myth is that Medicare pays for nursing homes. Medicare does not. Medicare pays for rehabilitation at skilled nursing facilities. You've got to be admitted. There's a cap. It's going to end at 100 days. And in all honesty, the Medicare folks don't want you to be getting the full 100 days. They're going to be evaluating consistently and double checking about whether you've reached, the estimated amount we think you're going to need care for. The next myth is that Medicaid facilities are separate institutions or wings and their shutters are all crooked and falling down and it's a terrible place. That is not true. Nearly every facility that provides nursing home care in Montana accepts Medicaid. And the simple reason is if you're at a nursing home, 65% of residents are using Medicaid to pay the facility. So from a nursing home perspective, that's, over a majority of their clients. They need to know, they need to get Medicaid to pay. They need to take those clients. So generally speaking, the folks who are aware that an individual is paying with Medicaid are not the people providing care. It's just a back end bookkeeping issue. All right, next myth. If I need long-term care, I'm going to lose everything I own to the government. I get where that's coming from, but that's not necessarily true. So Medicaid has a lot of rules that are designed to protect you and your family and your spouse so that you don't completely slide into poverty. But Medicaid eligibility does have very low asset thresholds. And so it is possible you're going to basically run out of assets. And then from a technical standpoint, it's not Medicaid that you're losing your money to, it's the nursing home corporations, because they're the ones that you're paying your money to, and then Medicaid will reimburse them. All right, finally, myth. Medicaid means I get worse care. Similar to the second myth, it is discriminatory for a facility to change how they provide care based on how you pay. And staff don't know. They're not the CNA, the care providers, they're not the ones who are generally aware about how the care is being provided. It's a back end issue that the accountants are dealing with. So having Medicaid pay for care is not unusual. Most folks, a lot of folks end up qualifying for it. The goals ultimately today, when I talk about Medicaid rules, are I just want us to appreciate that Medicaid rules are complex. I want us to spot potential issues before you apply, because as you'll see, some of the rules for Medicaid are going to set you up where you can't fix things. Ideally, you recognize when you need someone who's an expert in the field. And I would really like us to avoid clear errors. I'm going to talk today mostly about Medicaid rules. I'm not going to talk about the process that we go through if you were going to apply for Medicaid, so on and so forth. I just want to talk about the rules so that we have an idea about what the game is, okay? Generally speaking, we're talking about giving elder law avoidance rules, Medicaid avoidance rules. We're not talking about evasion. When I'm doing a Medicaid application, we're going to disclose everything that we possibly can so that the caseworkers make the right decisions. And if you're going to hire an attorney to help you, you need to tell your attorney all the facts so that they can give you the right advice. It's the attorney's job to make sure that you know what the rules are and you have the opportunity for them to explain your choices. Medicaid fundamentally is a bureaucracy. And so there's lots of documents that you need to provide them. Having those documents ready to go is really important, because it's not uncommon for you to have to go and get documentation like a life insurance contract or an annuity contract. And if you have to go and talk to the annuity company, it might take 3 or 4 months to get that contract. And when you're needing to pay the nursing home right now, that can be a real challenge from a timeline perspective, right? So just knowing, hey, it's going to take a lot of documents, we got to gather a lot of things, that's going to help you adjust your expectations about how the process will go. From a professional standpoint, the Medicaid caseworkers are gatekeepers. It's their job to sift out the people who qualify and the people who don't, right? So they see lots of Medicaid applications on any given day. They don't know who qualifies. They don't know who doesn't qualify. So they're trying to figure out, based off the documents you've given them, do you qualify or not, right? Their job is not necessarily to give you advice about what you should do or should not do. Same with the nursing homes. Their job is to provide the care for you, and they do that in exchange for money, right? Their job is not to make sure that you save as much money as possible. Their job is to make sure that you get the care. So the question I have is, if any one of the Medicaid caseworkers or the nursing home folks help you submit an application, who's going to help if your application is denied, or who's going to help if the caseworker makes a mistake, which happens periodically. So it's important to just recognize both institutions, nursing homes and Medicaid, are an institution of people. Generally, everyone's doing the best they can, trying to help people. They're there because they want to help people in the first place. So in general, in order to be eligible for Medicaid, you got to be sick, old, and broke. Old, I mean 65 and older, blind or disabled. And the disabled, that means you need to have a Social Security Administration determination. Sick, generally speaking, that means you're going to need, you need help with at least 2 of your activities of daily living. And in the long-term care arena, we talk about level of care in terms of help with your ADLs. Your ADLs are, activities of daily living, including feeding, bathing, going to the bathroom, dressing, getting in and out of bed, walking around the house. And broke, basically what that means is you need to have less than $2,000 of what we call accountable assets. And then you need to have less income than the cost of care. If you can meet all those requirements, generally speaking, you're going to be approved for Medicaid, right? Now, when I say broke, obviously not all assets are going to count about these countables. So we'll talk about that in a little bit. But that's a real basic overview about what you need to what you need to meet to qualify for Medicaid. So Medicaid is a public policy program. Congress has recognized the fact that it's very expensive to pay for care. And they have said, look, it's important for us to make sure that people who can't afford to pay for care still get care. So here's a program that's going to make sure that works, right? That's how I think about Medicaid. That's how Congress thinks about Medicaid. That's how the caseworkers think about Medicaid. It's important that we understand this program through the lens of it's a public policy, okay? So there's going to be lots of rules and exceptions that make sense in this context of we want to make sure someone's taken care of if they can't afford it, right? All right. So to talk about income first, in order to qualify for Medicaid on an income basis, the general rule is you need to have less income than cost of care. If you have more income than the cost at the facility, then generally speaking, we would say you have a sustainable method of paying for care. So for example, if I had an income of $8,000 a month and the assisted living facility was charging $5,000, that's affordable, right? We don't have to liquidate assets to pay for care. We can pay for care for as long as necessary and continue having enough money to pay the facility. We're always going to be deducting what we call qualified medical expenses when we're talking about cost of care. So that's going to include Medicare, prescriptions, insurance premiums, long-term care premiums, etc. So our first public policy rule here is that if we have a married couple and one spouse needs care, at a nursing home, we want to make sure that the person who's not needing care, the person in the home, still has enough money to live on their own, right? We don't want the well spouse to have to get on food stamps and, you know, Section 8 housing and TANF in order to meet their basic needs simply because their spouse is at the nursing home, right? So the policy to protect that well spouse is what's called the minimum monthly maintenance needs allowance. And this is a protection for the well spouse, which basically says that the well spouse gets to keep at least $2,178 a month. And if that number is made up entirely of the well spouse's income, so if the well spouse has $4,000 of income on their own, then the well spouse keeps $4,000. But if the well spouse has $200 of income, then they get to pull money from the ill spouse, the person who's in the nursing home, to make up and keep at least $2,178 a month. So what happens is if husband is at a nursing home, they're going to keep $50 a month, and generally speaking, the remainder of their income gets paid to the nursing home, right? From there, Medicaid covers the difference. So that's why we need Medicaid, to make sure the facility is paid on an ongoing basis so they agree to continue providing care. But we can rest assured that the well spouse is always going to get to keep at least $2,178 of available income to meet their monthly needs. That $2,178 is adjusted annually. So this is the number for 2022 that will go up in January. Let's see here. Okay, let's talk about assets. This is where most people spend a lot of time in Medicaid. And this is where things can get kind of complicated. So generally speaking, there's two categories of assets for Medicaid. There's what we call countable assets, then there's non-countable assets. Your countable assets are all the assets that you can liquidate to pay for care. This is going to include bank accounts, brokerage accounts, IRAs, 401ks. You know, if you got a life insurance policy that has cash surrender value, that's a countable asset. It'll include some real estate, and it might even include gifts. And we'll get to gifts in a second because there's special rules on that. One note at the very bottom here, it says non-countable assets in a RLT or a LLC. So RLT in my world means a revocable living trust or a limited liability company. So for example, if you have your primary residence in a revocable living trust, note your very first non-countable asset is your primary residence, right? But if it's in a revocable living trust, Medicaid rules specifically say that counts. Okay. So just because the asset is generally non-countable, if it's in some other entity, that's going to cause a problem. So all the assets you can liquidate to pay for care, those are your countable assets. And then your non-countable assets are all of the things that have a specific carve out. So Medicaid has provisions and policies that are that they put out, and those are based on federal law and state law and department policy rules. So you got to have a specific exception to have an asset not count. So your general non-countable assets are going to be your primary residence, as long as your spouse is living there, or you plan on leaving the nursing home and going home within 6 months. So it's a contextual rule, right? So if you go to the nursing home initially and you thought you were going to come home and you end up not being able to go home, it could be that your asset was a non-countable asset and then a countable asset over time. Similar non-countable assets are one vehicle of any value, any irrevocable prepaid burial policies, term life insurance doesn't count, household goods, personal effects, and some annuities. Okay, those are generally speaking the assets that are not going to count towards your asset thresholds. All right, so in the countable assets, I added gifts, and that's because the gift rule from a Medicaid perspective is unique, and this is what most folks understand as, you know, what we would call the 5-year look back period. And generally speaking, what this rule means is from the day you apply for Medicaid, they're going to look back, the caseworkers are going to look back 60 months, and they're going to see if you gave any assets away for less than fair market value, right? Fair market value is, you know, if you paid $10,000 to a car dealership for a vehicle, that's a fair market value transaction, right? You paid money, you got a car in exchange, right? Or if you sold your house on the open market, you're trying to get as much money for that house as you possibly can. So when you sell it, the presumption is you sold it for as much as you could. That's not what we're talking about here. We're talking about a transfer from a Medicaid perspective is an asset for less than fair market value. So these are going to be transactions like putting kids on bank accounts or putting kids on the home, put their name on the deed. This might be gifting, so giving $10,000 to a kid, or you know, giving the kid the house or a vehicle, right? And it might even include you know, Christmas gifts or birthday gifts. Notably, there is no asset cap, or there's no dollar amount here. It's just, did you give an asset away for less than fair market value or not? One of the common misconceptions I hear a lot in the Medicaid context is, oh, well, we've been gifting, you know, $15,000 a year to the kids. That's not a Medicaid problem. That's not true. That $15,000 number that people hear, that is an IRS rule. That has nothing to do with Medicaid. If you give $15,000 away to a kid, Medicaid can give you a penalty if you apply for Medicaid within 5 years. So it's important that we spot these, because 5 years is a really long time, right? The caseworkers are looking for that, so they can ask for up to 5 years of bank statements, and they're going to want to see, I want to see the bill of sale, I want to see the closing statement on the house. They want to see evidence that shows that these transactions were done at fair market value and not gifts. Okay. Now, if Medicaid finds a gift, what does that mean? So the calculation essentially takes place once eligibility has been determined. And so what that means is you have to have applied for Medicaid. Medicaid has to say, yes, you have less than your $2,000 of assets, but you gave assets away for less than fair market value. So we're going to give you a penalty. The Medicaid penalty is a period of time in which Medicaid is not going to pay for your care. And the way that is calculated is Medicaid takes the amount you gave away for less than fair market value, and they're going to divide it by $271.41. And that might seem like a random number, but that is the regional cost of care per day at a nursing home in Montana. Okay. So what they're doing is they're creating a disincentive to gift assets. They say, look, even if you gift assets within the last 5 years, you know, you're not going to get an advantage because we're just not going to pay for care for that long, right? So if you gave assets away, Medicaid's not paying for care for as long as it would have taken you to spend those assets at the facility. That is how the penalty works. And so if you gave a house away, you know, which was say $200,000, you can be looking at a significant penalty where Medicaid is not paying for care, but you've just proven that you don't have the income and you don't have the assets to pay for care on your own. If you're not careful, the Medicaid penalties will put you in a very, very tight spot. So once the penalty has ran, then Medicaid can step in and start paying. And depending on how long that penalty is, you might need to resubmit a new application at that point. But while the penalty is running, the obvious question is who's going to pay for care, right? And that can get very complicated and very, very stressful. There is nothing that is going to protect an individual from an eviction if they've given assets and can't get those assets back. There's not a protection in the law about protecting that person from eviction. Now, the nursing homes, they can't do a discharge. They have to do a safe discharge, right? So they got to make sure that it's safe for you to go where they're going. But generally speaking, if you're not paying the bill, then you're in a really tight spot. There are some very common ways to avoid Medicaid penalties. And so the basic ones are these. So number one, you provide evidence to Medicaid that the transfer was for fair market value. That's not really avoiding a penalty. It's just saying, no, we didn't gift assets. There was actually fair market value here. And so what I see in my work is this is primarily a matter of getting the right evidence in front of the caseworker. So the horror stories that happen in my head is every month I see a cash withdrawal of $500 by mom who now has to go to a nursing home, and she's been doing that for 4 years. And there's nothing nefarious there. She just likes to deal in cash. Lots of older folks handle things that way. But the problem from a Medicaid perspective is they don't know what the $500 was for, right? It could have been a gift to a niece, could have been a gift to a nephew, could have been for groceries, right? But Medicaid gets to investigate those issues. And so they're going to say, all right, we want to see receipts, total them up, make sure they count for $500. And as long as the receipts are services or goods, then you're right, no penalty. So it's important that you gather that evidence. Maybe it's a bill of sale, et cetera, so that if Medicaid finds these transactions, you can then say, oh, here you go. Here's the evidence. This was for fair market value. There's no penalty. Second way to avoid a Medicaid penalty is that the transfer was done outside the 5-year look back period. So remember, our look back period is 60 months from the date we first applied, right? That's when Medicaid can issue penalties. The inverse of the rule is if assets were gifted more than 5 years before you apply for Medicaid, then no penalties can be given. So there's times when the right solution, if we know that there was an asset that was transferred, say 4 years and 10 months ago, we would say we need to figure out how to pay for care for 2 more months before we submit our Medicaid application so that we get through our look back period, right? Now, one of the major questions is, well, when does our look back period start? The obvious answer is it starts when you first apply for Medicaid, but there are some exceptions or additions to that rule, which basically we'll look at when we start looking at this spouse protections. A resource assessment in Medicaid world can count as a Medicaid application. So number 2 is really important from my perspective because nursing homes will often help folks apply for Medicaid, right? And they're not the social worker who's doing the Medicaid work is not necessarily doing a 5-year investigation to figure out whether you gifted assets over the last 5 years, right? They're saying, I want to see an updated bank statement. Let's get your birth certificate and your driver's license and all that submitted to that Medicaid. That's what they're doing, right? They're not going to know about whether gifts were done. And so submitting a Medicaid application can have significant long-term consequences. The other, you get one look back period from a Medicaid perspective. Your first Medicaid application is the date your look back period starts. If you apply and you get denied and then you figure out how to pay for care for 3 more years and then reapply, your 5-year look back period started on your first Medicaid application. So we don't take submitting Medicaid applications lightly. All right. Number 3, your transfer was exempt. So there are specific rules that say, well, if you gave an asset away in this context, we're not going to give you a penalty. And these exceptions are based off of federal law that Congress has put in place, again, due to public policy. So the first one is you transferred assets to your spouse. That's not a huge deal because when you apply for Medicaid and you're married, Medicaid is going to count both of your assets together. So you don't get an advantage by giving the house to your wife. There's no value from as far as saving assets. But once you are approved for Medicaid and you're married, you do need to get all of the assets in the nursing home spouse's name out of their name so that they have under $2,000. And so generally speaking, when you get your approval letter, you've got about 90 days to get all those assets out of the nursing home spouse's name. The second transfer that is exempt is transferring assets to a disabled child. There's not a cap on how many assets are gifted to a disabled child, but the key issue with this exemption is the child has to have a disability award letter from the Social Security Administration. Veterans disability, railroad disability, life insurance disability, none of those count. Those are not acceptable disability standards. It's Social Security Administration or nothing. Okay. So if you have a disabled child, the public policy basically is, well, we want to make sure, someone who's disabled also has enough assets so they don't have to go on public benefits themselves, right? We can give assets to a child who's disabled. All right. The last exempt transfer that we're going to talk about is what's called the caregiver child exemption. And this is a very specific transfer, and it's got to be the applicant's home. So this is a situation where an individual person was living in the home, a kid was living in the home with that individual, and the child took care of the applicant for 2 years, and the care that the child provided kept that parent out of the nursing home. Okay, so what happens is their dad's living in the home, son's taking care of dad, they live in the same home under the same roof, right? 2 years, kid lives with dad then gets so ill that son can't do it anymore. Dad goes to the nursing home, and you can transfer the house to the child's name. You got to have a doctor's letter which specifically says that the child provided care that kept the parent out of the facility. And more importantly, the other major rule here is you cannot go from the home to an assisted living facility or an independent living facility. You have to go to a nursing home. So if you're going to go from the home straight into a nursing home, this exception works. If you go from the home to an assisted living or even a memory care, this is not going to work. You're going to get penalized. Okay. So we don't take these transfers lightly. We got to make sure that we're going to meet all of these requirements. But if we meet them, the house can get transferred, right? And again, it's a public policy. So we want to encourage children to take care of parents. We want to try to keep people out of the nursing home because the nursing home is expensive. Most people don't want to go there, right? So we want to encourage kids to take care of parents. And so Congress has said, okay, kids, if you take care of parents for 2 years, then you can get the house. That is the theory here, right? So those are the limited exceptions that exist to avoid a penalty. Every other transfer that you don't get fair market value for is going to get penalized if it's in 5 years. All right. So we're going to talk about Medicaid eligibility for a married couple. Plenty of clients. I have lots of clients in this particular case. Often, but not always, often it's the husband who's ill. He ends up needing more care than the wife can provide. right? And so we want to make sure that the wife has enough money to live in the community on her own. And we want to make sure that the family as a couple have spent a fair amount of money on care, on their own, right? We want to make sure they've paid their fair share. And so the public policy here is we want to make sure that the spouse is provided for, make sure that she doesn't or he doesn't go on public benefits themselves, and make sure they can live in the community. And so what Congress has created is what's called the Community Spouse Resource Maintenance Allowance. This is a fun, complicated rule, but the idea is we want to keep enough money in the spouse's name. And so the way that this rule works is the first day that husband goes to a facility for 30 days is our snapshot date. That is the day that Medicaid is going to do what's called a resource assessment. And that resource assessment is a value of all the assets that the couple has on the snapshot date. And Medicaid is going to break out what assets count, which ones don't count. And they're going to say, okay, your countable assets equal X. We divide that in half. Half has to get spent, and the other half can be kept by the community spouse. Remember when I was talking about the 5-year look back period, and I said resource assessments can be Medicaid applications. In this context, if you submit a resource assessment with no Medicaid application, that will be treated as a Medicaid application and start your 5-year look back period. So keep that in mind. But when we have our community spouse resource maintenance allowance done, we now know how much money the individuals need to pay privately before Medicaid is going to step in. Now, the CSRMA has a minimum and it has a maximum. And so if you have $1 million of countable assets, the community spouse doesn't get to keep $500,000. The maximum CSRMA that exists for 2022 is $137,400. And so what that means is if you had $1 million, you're going to be spending, right, roughly $800,000 paying for care. So there's not a huge incentive, to be applying early. There's an incentive to know exactly when it makes sense to be considering Medicaid eligibility. And if you have a net worth of under $50,000, you're always going to get to keep at least $27,480 as the community spouse. So those are your windows that the community spouse is living within that they get to keep. Okay. So the 50% of the countable assets that's got to get spent, the general idea is once we've spent that money and we're underneath our CSRMA amount, we're eligible for Medicaid. You can apply for Medicaid. Medicaid will start paying the facility. But the question is, what do you do with your spend down amount? And the most straightforward answer is you pay the facility. And that is very true. Lots of folks do it. And after, however long it takes to pay the facility your spend down amount, you can apply for Medicaid, not a big deal. But there's no rule that actually says you have to apply for Medicaid or you have to pay that money to the facility. The only rule is you can't gift that money away. So we want to look around and we want to say, what else do we need that we can spend this money on right now? Maybe that's paying the mortgage. Maybe it's paying off a car loan. Maybe it's putting a new roof on the house, right? Maybe it's buying irrevocable prepaid burial policies. There's lots of things that maybe we were pushing off, not buying because we said, we don't have enough money, things are tight right now. Well, you run the numbers. If we're needing nursing home care, we might say, we're going to pay it to the facility or you're going to buy a new dryer, this weekend, right? So knowing how much money we've got to spend down before we're eligible can help you take advantage and use your money efficiently. All right. That is called the Community Spouse Resource Maintenance Allowance. So I just had a couple examples quick, just so you can see how this tends to work. But Harold and Shirley, they're 75. Harold's got dementia. He can't live in the home any longer. He fell August 1st and he was admitted. Discharged to the nursing home for rehab. Nursing home has a slot for him and they're willing to accept it. And one thing to note here quite often is if we're actually in this situation where Harold and Shirley are living together, Shirley's been providing a lot of care to Harold already, right? She's probably, in all honesty, been drowning. And one of the concerns I have quite often is the community spouse might be the well spouse, the caregiving spouse might be the person who dies first simply because they worked themselves to death, right? Folks, people in these situations are not always asking for help. We got to keep an eye out and make sure that they're aware that there's help out there. So Harold and Shirley have a house. They've got vehicles of $200,000. Shirley's got an IRA, or vehicles of $20,000. Sorry. Shirley has an IRA of $100,000 and Harold has a brokerage account of $100,000. That's what they owned on August 1st of the year of when Harold went to the nursing home, when he triggered his snapshot, right? So our snapshot is August 1st. That's the day that Harold went into the hospital. 30 days. The resource assessment is going to conclude that there's $200,000 of countable assets and there's $420,000 of non-countable assets, right? Our countable assets are the IRA and the brokerage account, and our non-countable assets are the house and the vehicle. So the resource assessment is going to say, okay, Shirley, you got to spend $100,000. And once you're under your $100,000 CSM RMA threshold, you can apply for Medicaid and we will start paying for care. So $100,000 is set to be spent and $100,000 is set to be kept. Again, we don't get to gift these assets, otherwise we're going to incur a penalty. So the question is, what do we do with $100,000? Maybe Harold and Shirley have a mortgage. Maybe they've got a lot of credit card debt. Like I said, maybe we're going maybe we're going to pay to get the driveway done. Maybe we're going to buy a new vehicle for Shirley to make sure that she's got a reliable vehicle for the rest of her life. If we run out all those assets, all of those items, and we still have money, then we're going to pay the facility, right? And once we're under $100,000, we're going to apply for Medicaid. Every month you've spent underneath your CSRMA and you're still paying the facility, that is a month that you do not necessarily need to be paying for care because Medicaid will have stepped in. From a nursing home perspective, Medicaid will pay back up to 3 months in arrears. And so if you have 3 months of debt outstanding at the nursing home, then you apply for Medicaid. You can ask Medicaid to step in and pay those last 3 months as long as you were eligible for each month. So you got to show to Medicaid that you qualified, that you had under your $2,000 and you were under your CSRMA amount. If you can do that, Medicaid will step in for the last 3 months. All right, a couple final notes on the long-term care. Maybe we'll talk about some estate planning, but generally speaking, when we're talking about admitting a loved one, every facility is different. I have lots of folks clients who are in every facility that I can think of. Some people have good fits. Some people don't fit with a particular facility. You got to go and look. You got to talk to the staff. You got to talk to the people who are there. Visit when no one's expecting, not to be like evil, but just to see how things are working, right? When you're admitting your loved one, make sure you're signing. If you're signing on their behalf and you're using a financial power of attorney, make sure you're signing your name, comma, agent for the principal. You want to make it very clear that you're not signing individually. Technically speaking, it's not legal under the federal laws for nursing homes to go after children, but it's better to be clear, right? Additionally, when we're talking about Medicaid eligibility, just because an asset is a non-countable asset does not necessarily mean that it's saved. Because Montana is what's called an estate, we're an expanded estate recovery state, which means if Montana Medicaid wants to get the federal money, they've got to pursue estate recovery, which means they're gonna go after and they're gonna try to get paid back from any assets that you owned in your name when you died. Medicaid can be a creditor of your estate. Okay, so if you had a vehicle that was a non-countable asset and then you passed, it's possible that that is going to have to get sold and paid to the nursing home, or more likely Medicaid. That is going to include bank accounts that transferred with transfer on death or payable on death beneficiary designations, revocable living trusts, revocable transfer on death deeds. Those are all things that are going to be subject to estate recovery. All right. So someone asks, what happens if the couple have a mortgage, taxes, electric, water, gas, medical supplements, car payments, etc., to which are greater than the community spouse allowance? That is a good question. Generally speaking, there are, when we're talking about the income eligibility perspective, you can ask the facility, or you can ask the department for an increased number here. I think it goes up to 3,500, but you've got to have the evidence and you've got to go to a fair hearing to do it. I don't think I've ever gone through that situation myself, and so I don't see it that often. We normally try to figure out a different way to pay for care. I want to talk. I think I'm gonna run short. So I think, Brenda, at this point, I'll kind of pass it back over to you because I've got 5 minutes left, but everything else was going to be estate planning. So that's its own large group of topics.
Okay. How many slides do you have left on your PowerPoint?
One.
Okay.
Here's these are a bunch of resources that are available to anyone. These links, I'm happy to give this to you, Brenda, if we need to make these available, but 42 USC 1396 is the federal law for Medicaid eligibility. The MCA is the Montana Code Annotated. Those are Montana's rules. And then the fourth link here is the DPHHS regulations. And these are the manual department rules that are specific to Montana Medicaid. So there's some other links about some other stories that have just recently been in the news about long-term care. The ABC news story is about nursing homes who were out east. They're pursuing children. The NPR news story is a really cool story about a child caregiver who was taking care of her mom who had dementia and doing self-help on TikTok. So I just saw that one today. And then the Genworth is the study about cost of care.
I'm going to recommend that the folks that have logged on to this is a very good slide to keep up and just take a quick screenshot so you have these web links. And Steph and I see, looks like 4 more minutes on this. So any closing thoughts you'd like to give everyone?
I think the biggest kind of takeaway that I have, having done Medicaid I practiced Medicaid planning for 5 years. That's basically all I've done the last 5 years. And the interesting thing is everyone who's here is trying to help people, right? I think that if you go out looking, you're going to find lots of horror stories, but you know, the folks at Medicaid, they're not evil people. They're trying to help, right? The folks at the nursing home, they certainly are trying to help. The challenge is the Medicaid rules are very, very complicated. And if you don't know what rules are coming into play, you're basically guessing about where you're going to fall and what you're going to have to spend. And so the goal, you know, generally from my perspective is we want to know what's going to happen before we jump, right? I want to know my landing spot every time. So that's, you know, the Medicaid rules are complicated, but there's a path forward for everyone. So
We have a final question in the chat. Someone is asking if attorney fees are an allowable expense.
yes, they are. When you're talking about your spend down as far as the CSRMA or getting down to $2,000, you know, that counts. So you pay an attorney to go write an estate plan to make sure that you have a valid financial power of attorney and healthcare power of attorney. That is money that's well spent, and it's a fair market value transaction, no penalty. Yep.
All right. Well, I believe at this point, if there's anyone else who wants to put some final questions in the chat, we have about 2 minutes left. So Stefan, if you could perhaps give us a sense of if folks are looking to do some estate planning, any quick within 1 minute resources they can tap on that topic.
Yes. So the Supreme Court has plenty of documents that are available for you to write yourself. So if you go to courts.mt.gov, there's a top soft tab that says forms, and from there there's a link that says estates. They've got a sample will, they've got a financial power of attorney, a healthcare power of attorney. Marcia Getting over at MSU Billings writes with Mont Guide. She does fantastic documents as far as she's got some Medicaid pamphlets for the Missoula or the MSU Extension Office. If you're looking for information, that's probably one of the best resources that exists in Montana. So the MSU Extension Office has good information on Medicaid and estate planning. And then Montana Legal Service Association, their website, Montana Law Help, has links to the Supreme Court website as well. Yeah.
All right, very good, Stefan. Thank you ever so much for your wonderful presentation, and thank all of our participants for coming to our Citizens Law School. We will be having another presentation this same time next week, and I invite everyone to attend. That one will be on the role of the courts, a day in the life of a Montana judge, and we will be featuring the Honorable Mike Menahan of the First Judicial District of Montana. And so on behalf of the State Bar of Montana and the Law Related Education Committee, thank everyone for attending, and I hope we will see you all next week.